Welcome back, viewers and subscribers of AVG News. My name is Motsoaledi, the son of Ncube, and I would like to have a few words with the Zimbabwe exemption permit applicants following the court ruling that we spoke about yesterday, which gave ZEP holders an extra 12 months and ruled against the Minister of Home Affairs, Dr. Motsoaledi. You will remember that following court cases that were taken to a hearing, the Pretoria High Court ruled that the decision by the minister to discontinue the Zimbabwe exemption permit was unconstitutional, and also gave a moratorium of 12 months for Zimbabweans who are on the Zimbabwe exemption permit to continue living and working in South Africa. So the minister has already responded to that, and what he said is that the government is going to appeal. He has already given his lawyers, his legal team, an order, or rather an instruction to appeal this court ruling. So what this means is that the reprieve that Zimbabweans were celebrating yesterday has been, for now, a short-lived one, because as we expected and as we said to you yesterday, the minister is appealing the decision. It was speculative on us from us yesterday, and we said that it's highly likely that Dr. Motsoaledi is going to appeal the court ruling, and he has already done that. And you'll remember that yesterday also we advised ZEP applicants to wait for the statement, for an official statement from the Department of Home Affairs, especially the minister, as to what they're going to do with the court ruling. Are they going to abide by it as they had promised earlier on, or are they going to appeal it? And now the issue is that Dr. Motsoaledi has instructed his legal team to appeal the court ruling, and he's arguing that what the court did was to override his ministerial decision. It was to also conflate the duty of the executive with the duty of the judiciary, and therefore he is appealing this because he believes that the court ruling hamstrings him rather to being a subject of the court instead of being a subject of the executive, as a minister who is supposed to take ministerial decisions based on the best interest of South Africans and the Zimbabwean exemption permit holders. So what he's saying is that permit holders are already applying, many of them have already applied for the for the waivers that he made available for them, so that if they don't qualify directly for permits, they can have some of the regulations under the Immigration Act waived using his powers as the minister. And is arguing that many Zimbabweans have already taken up that option and they're busy applying for waivers and he's signing them. So this is part of his argument. So what does this mean to Zimbabwean exemption permit holders who were left in limbo as to whether they should continue applying for waivers and honoring appointments, or they should stop? So what this means is that the court ruling has been appealed. It doesn't set it aside, but what it means is that unless and until a hearing of the minister's appeal is taken into consideration, the recent court ruling cannot take effect. What this means is that but right now the appeal hasn't been made, but once it's been made and it's been taken to court, then a new ruling will take precedence. If in his appeal the minister wins the case, it therefore means that the recent court ruling, which we are celebrating now, is overturned. If the court ruling that the minister is appealing is upheld, then that means that the Pretoria High Court's ruling that we have in hand right now will take precedence. It will be the one that is effective. So what this means to ZEP applicants is that you should go back to back to square one. You should continue with what you are doing, continue applying for the ZEP waivers. Where you have been granted a waiver, continue to apply for the permit that you believe you qualify for as per the decision on the waiver that you got. For those who have appointments that are outstanding, continue to honor them. For those who have already applied but haven't paid at VFS, the 1,550, if you applied for a waiver, continue to pay. For those who have paid but haven't booked an appointment, continue to book, because what this means is that the next court case can drag on to and maybe next year, because what the minister has vowed to do is that he's going to take all necessary steps, exhaust all legal channels to fight this. And this means that it's going to be a very long, protracted legal struggle, and the dates are moving. If, let's say, the court cases drag up to the Constitutional Court and it takes us to June 2024 and you still haven't done anything, and the minister wins the case, it means that you've been shut out. If also this takes us to December 31 and the minister wins this case, this appeal, it then takes us again to the first point that you've been shut out. But in the event that the minister takes it all the way to the Constitutional Court and loses, there obviously is going to be restitution for those who would have applied for waivers and paid for them. There's no way that you will be let to lose your money. So either way, you ought to have applied, you ought to have followed the channels that were given until the finalization of this court case, so that you are not found wanting in the event that the minister eventually wins his court case. So that is what we had for you right now. Continue to ask questions using the comment section underneath this video, or you can inbox us. You can also search for our page on Facebook, AVG News, like that page. Ask questions there, whether inbox or on the timeline. We prefer for you to ask on the timeline, so that when we respond to you, we also respond or we also address similar issues for other people who may be facing a similar problem as you. Do not forget again to subscribe to this channel, to like this video, and to share it. Thank you. Have a wonderful rest of your Friday and a wonderful weekend.